Office of Hazard Material Safety Field Operation Inspection Investigation Enforcement Manual version 2.0, effective date October 5th, 2017. This is an update file. We're reading the update. Chapter 4, Enforcement Penalties, Non-Enforcement Actions. PHMSA enforces penalty procedure preparing with the initiating civil penalties and other actions found with the Title 49 CFR Part 107, the Subpart D of the AHMS and PHC. Have authority to take action known violation of the hazard material regulations. The AHAMS has the authority to issue sanctions, including advisory letters, warning letters, tickets, and has delegated this authority field operations staff. The PHC has delegated authority to issue compliant with the orders from civil penalties, notice of probable violations following an inspection under circumstances the AAFO designee believe the person has committed substantial or serious violation of the hazard material regulations. These cases are referred to as the PHC. PHC receives the case the referral assigned to an attorney. The attorney will contact the investigators to discuss the case with asking the question, clarifying the issues, could possibly request additional information for the documentation, investigator participation of the PHC. Critical thought throughout the process after the interview with the clarification and the referral package, the attorney prepares the issue for the notice of probable violation of the basic documentation of the PHMSA to bring civil penalty enforcement action for the NOPV or the notice of probable violation and provide the evidence for the supporting violation for the maximum penalties authorized and the proposed penalties. Also describe the course of the action available to respond with the notice of probable violations that also compromise. Complying with the notice of probable violation will include the statement of the proposed action to be taken of the respondent. If the issue of the complaint with the notice of the probable violation is an issue violation only with the allegation of the penalties only proposed, the case is to still be modified even with the withdrawal of the subsequent fact warrants with the compromise is reached with the respondent. The respondent has 30 days to respond with the notice of probable violation. The 3 choices paid with the penalty submitted with the informal respondent. 3 request a formal hearing before an administrative law judge. If the respondent pays the penalty, the investigator will have no further involvement in the case of the closed out of the PHC. If the respondent elects to submit the informal response, the respondent may submit the written response for the PHC. Request the informal conference or both of the written informal responses submitted. The attorney will provide with a copy of the investigator evaluation input. This will normally be accomplished via email or telephone. Informal conference. The informal conference is scheduled with the investigator and the attorney will discuss in advance of the major issues that might arise. The informal conference are usually conducted via the telephone or on occasion face-to-face. The attorney is a moderator with informal comments and should lead with the discussion. Investigators are present to provide the factual statement regarding the inspection. 2, the address of the statement have been interviewed by the respondent, the investigator, and the attorney will conduct with a post-conference with the debriefing to discuss the conference for the any issue that needs resolution. Administrative law judge hearings of the respondent record for the administrative law judge hearing. The PHC consultation with the DAFO will determine whether or not there is genuine issue with the material of the fact before making any of the formal request of the service of the administrative law judge. PHC will attempt to informally resolve the issue cannot be accomplished by hearing with the range for the PHC. The investigator role hearing is largely the same with the informal conference, with the except that there might be called appear as a witness for the government with the testify under oath and the event of the hearing with the schedule the attorney shall inform the investigator of the specific requirement of the procedure preparing the investigator for the hearing. The investigator will assist the PHC with identifying with the other appropriate witnesses. Order following the informal response of the administrative law judge hearing. The formal order will be issued finding with the violation have not occurred with having an excessive civil penalty or complying with the order. Respond with the chief of the council may opt for the compromise for the order amount of the penalty. Title 49 107 327. Describe the process for how the compromise orders are to be handled. The investigator involved in the case of the normally and conclude with the issues and order appeal. The respondent may elect to appeal the order in accordance with the Administrative Procedure Act. With the appeal of this directive of the PHMSA administrative. In this case, the order of the administrative law judge of the PHMSA also may with appeal. The decision case involved in the appeal order will be assigned with the junction attorney with representative of the administrative the conduct of the independent review of the entire case file. But the investigators will only be involved with the appeal. Then respond with the challenging material with the fact that the issues related with the inspection or other matters with directly involved with the investigator. Otherwise, the PHC will provide the chief enforcement branch and information for the copy of the respondent. Appeal of the administrative decision is appeal of the case is called the action on the appeal. The administrator may uphold the order with the modified the order eliminating the violation and or reducing the assessed penalties that are made to dismiss the case entirely with the violations not dismissed. The respondent may either pay the penalty of the file of the appeal with the United States of the Court of the Appeal District where the respondent resides. The criminal penalty investigator may encounter the situation involved with the various serious violations of Regulations apparent with the willfully intent with the part of the violator within the situation. PHMSA discretion initiated the criminal investigation referral for the Inspector General of the Field Operations Staff of the PHC's leadership will work together to decide the course of the action with the criminal investigation. Injunction of action. PHMSA administrator may seek with the relief of the Department of Justice of the person with engaged in any of the practice involved with the violation of the Federal Hazardous Materials Transportation Law regulations issued thereunder. The relief could be informed, mandatory, prohibitive injunction relief within term of equitable relief and the punitive damage relief. The type of the must often be sought by the PH if they determine the substantial likelihood of the death, serious illness, serious personal injury will result from transportation, particular hazard material containing such as the situation usually determined by the minimum hazard situation. Relief that can be sought prior to any other action perceived with a reduce the risk of the harm of the situation. Investigators should be aware of the possibility of such events with the reports of the situation management. The PHA field leadership will provide the guidance of the direction of the necessary. The ticketing program streamline and diminish the perceived the reduce the cost of the reduce of the regulatory burdens within this case and include the certain violation, most of which for the indirect impact of the safety involved with the regulatory requirements of the mandatory with the Federal Hazardous Material Transportation Law. The ticketing program affords the respondent the opportunity to respond with the violation by the agreement to the pay with the reduced penalty with the waive of the right for the full injunction by the PHMSA off the Chief of the Council via the civil deployment process described in Title 49 CFR Part 107. Sections 107.311 through 327. Non-enforcement recommendations. If the investigators serve a unique role due to the frequent contact with the related with the ability to directly observe the hazard material regulation is being applied, investigator duty extends beyond the reported violation hazard material regulations. Investigator must have the responsibility to provide the PHMSA officer along with the model partner with the language of the regulation, special permit, and the other policy it has affected beyond the intended purpose. When investigators find that the portion of the hazard material regulations approved with the level of the special permit and other policy deficiencies in contradiction not meeting this purported intent should step to be taken to document with the finding rational change, but the investigator should take with a photograph obtain the documentation, observe the reports of the taken, the detailed notes of the supporting the observation recommendation. Investigators should prepare for the email route through their supervisor, the administrator, the direct division director for the consideration email should include the following description with the observer who have the president with the observer the statement, the detail of the extent of the problem, the supporting evidence of the substantial recommendation help with the further understand the issue. Recommendations on actions necessary to correct the problem. Regulatory change for the support paper. The regulatory change support paper to provide for the formal method of the investigators to request the change for the hazard material regulation process entail the full evaluation of the proposed change for the regulatory change support paper. Allow the PMSA to prioritize the regulatory actions to be best achieve the safety goals like not limited economic impact of the federal government, the regulated industry, and general public. Additional to the standard rulemaking division, PHH 10 works closely with the program management data statistics division, PH 60, to ensure the regulatory change support paper are evaluated in accordance with the OHMSA Office of Hazard Material Safety Policy Analysis Protocol. The Office of Hazard Material Safety relies on the basic policy analysis protocol mechanism of evaluating issues and initiating action or action best addressed with the consequence of proposed change, rulemaking, outreach, targeted enforcement research, international position paper, and etc. Template for the regulatory change support paper is in Appendix B. Chapter 5, Conducting and Completing Fitness Inspections. Testing.